Hello everyone, this is Pieter Bekker, and I'm pleased to team up for the first segment of the program with Rob Vanderpoel, who is the creator of Keras Lots, which is the world's most sophisticated software for plotting boundaries. I am a former ICJ staff lawyer. Our pre-ruling analysis underscores how maritime boundary delimitation is part law and part science, the two disciplines being intertwined. And Rob and I will set the stage and provide a framework for discussion by Abdul and Albert. And we'll do so as neutrals, pretending there is no ICJ case. So we are disinterested observers from the outside. And I'll let Rob make an initial disclaimer before we start our discussion.
Thank you, Peter. Just make sure that everyone in the audience realizes every effort has been made to ensure the accuracy of the graphics. Nevertheless, these are illustrative, indicative, independent, and preliminary. And it is the request of both of us that any contained figures in the presentation not be used without the permission of either of us.
Thank you, Rob. Now, in terms of policy options, let's keep in mind coastal states with overlapping claims to maritime areas have a basic choice between finding a bilateral solution or seeking third-party assistance. And the United Nations Convention on the Law of the Sea, to which Somalia and Kenya are parties, calls for negotiation in good faith of what it calls provisional arrangements of a practical nature, pending final delimitation of an exclusive economic zone or continental shelf. That is a treaty obligation. Now, examples are the creation of a joint development zone where the disputing states agree to disagree on the boundary and then proceed to joint development of an overlapping claim area. Or international or cross-border unitization where a discovery is made. And these instruments enable the decoupling of questions of joint development from questions of sovereignty and sovereign rights. And the September 2017 ruling in the case between Ghana and Cote d'Ivoire is especially instructive regarding the legal obligations of neighboring coastal states with active offshore oil blocks but lacking an agreed boundary or a provisional arrangement for joint exploration and exploitation of hydrocarbons pending agreement on the common boundary. There's a helpful paper by William Moderator on the website of the hub that I can refer you to. Now, disputing parties can also seek to delimit the disputed boundary through negotiation or through non-binding mediation or conciliation by a third party. Or the boundary dispute can be submitted to a third party adjudicated solution, either through ad hoc arbitration or adjudication by a standing tribunal. And that's, of course, what happened here in the case of Somalia and Kenya. We have no agreed maritime boundary, or so the two countries appear to claim, and there is a pending case between these two countries before the World Court, or the ICJ. As a note, self-help through the use of force is prohibited by the UN Charter, and so you can expect not to see naval vessels clashing offshore. A body of maritime delimitation case law or jurisprudence has developed through at least 25 decisions rendered by various international courts and tribunals since 1969. And through a technique that Rob and I call maritime boundary reverse engineering, and relying on our legal and scientific expertise, we can apply the lessons from case law to a given dispute, such as the one between Somalia and Kenya, and try to make informed predictions regarding its outcome. And the ICJ is the undisputed front runner, as you can see, with a dozen judgments. Now, ICJ boundary cases on average take 5 years and 9 months to conclude. And in this case, we are actually marking the 69-month anniversary. So we are already on the wrong side of the mean in this case. Okay, so how does an international court such as the ICJ arrive at an adjudicated maritime boundary? What can we expect from the ICJ in terms of the limitation process? Certainty equity, and stability are integral parts of this delimitation process. So we can expect to see them play out in this case. And these three elements are reflected in a three-stage methodology developed by the case law. Now, the court can be expected to start by determining what is called the relevant area. And it does so by identifying the geographical context of the delimitation. And that includes relevant coasts formed by projecting coastal frontages that overlap, as well as protrusions and offshore features such as islands. Then the court will establish a provisional line, typically but not always, by drawing an equidistance line between adjacent coasts, as in this case, or a median line between opposite coasts. And the point really is typically not how to draw the line, but where to draw the line from. That is, what is the land terminus point? And we'll get to that in the presentation. Rob will show you the issues with the land terminus point and the equidistance line. The next second stage, the court will consider whether there are factors calling for the adjustment or shifting of a provisional line in order to achieve an equitable result. And these factors are called relevant circumstances, and the case law favors neutral factors of a geographical nature, such as a significant disparity in coastal length, over area-specific factors such as fisheries and oil concessions and oil wells, unless the parties have expressly or tacitly agreed on their location. Now, finally, and at a third stage, the court will verify that the unadjusted or adjusted provisional line does not, as it stands, lead to an inequitable result by reason of any marked disproportion between the ratio of the respective coastal length and the ratio between relevant maritime areas of each state by reference to the delimitation line. This is called the disproportionality test, and its application actually could result in an offshore island being given only half effect or no effect at all in the delimitation. Thank you. So what do we have here? Well, we are on the eve of a hearing. And you can see from this snapshot from the International Court of Justice's press release, we are less than a month away from the opening of oral proceedings in this case. We know that Kenya asked for 2 postponements, and the hearings were initially due to open in September, then were postponed to November, and now we're looking at the 8th of June. What do we know about the case? From the ICJ website, there is Somalia's memorial, which is an initial document, but that is from the 13th of July, 2015. The Kenya position is not yet released. That will be done on the eve of the hearings. And so we are not clear what the Kenyan position is in the case. And also the final submissions of the parties can only be expected on the final day of the hearings before the ICJ. We do know that the trigger for the case was, according to Somalia, Kenya's granting of commercial oil concessions in the area of overlapping claims. So that's the background. Now over to Rob Vanderpool.
Thank you, Peter. Okay, so this is going to be a demo. Law of the Sea is a global marine application that actually impacts 162 countries. As you see from this global slide, we're focusing in on this portion of the nearshore offshore waters for Somalia, Kenya for today's study. Just to set the stage a little bit, what is the status of maritime boundaries in the world today as of May 2020? There's approximately 501 maritime boundaries in the world. 250 of these are signed and or in force, which is about 49.9% of the world, which means sadly 50.1% of the world's offshore maritime boundaries remain unresolved and or in dispute. And so today, 1 out of every 2 boundaries are disputed, as is the case for Somalia and Kenya. Just to roll backwards a little bit, just so that you understand what's going to be discussed today. 14 years ago, we started to assemble a global database for data. There's over 95 terabytes worth of data. We subdivided the planet to cover the entire world into 8 regions, 2 for the polar stereographic. We've completed 1,800 projects in 142 countries, but today's focus will be using data only from the African compilation relative to where the desktop study will be covering these waters. Okay, maritime state of play, Central East African Indian Ocean, just to set some facts. The immediate offshore Kenya, Somalia, Indian waters covers 4 countries, primarily Somalia, Kenya, but we will need to look a little bit in the neighbors' waters of Tanzania and even the Seychelles. For this law of the sea application, these offshore waters covers just over 1 million square kilometers, but for this specific desktop study for Somalia, Kenya, we're looking at about 385,000 square kilometers geodetic. But again, as mentioned, the primary focus is on the yet to be resolved boundary, Somalia, Kenya. Present status, all 4 countries in question in our desktop study have ratified and have ascension to UNCLOS, so they're all playing by the same required rules, which is a good thing for doing a desktop study. One thing, desktop studies all begin with coastlines, so here's some quick numbers. In the study itself, we're only looking at this many nautical miles for Somalia, Kenya, again, lesser extent for Tanzania, Seychelles. Straight baselines, normal baselines are being used by these various countries, and I'll cover that in detail. And there's only 1 maritime boundary in the immediate study area, so there's 1 treaty, and so 1 bilateral treaty and 1 unresolved dispute, which we obviously know is our primary focus. Just some interesting background. Experts are expecting big oil discoveries in East Africa. This could significantly alter the area. Results of recent studies in the East say it could become one of the world's hottest oil zones. These type of rocks from Sudan oil are going down into Kenya, and also offshore Somalia has promising oil reserves. Now, these are just internet references, but what it means is this area is a potential hotspot for hydrocarbon for the offshore. And that's why obviously we need to look at this maritime boundary. Law of the sea by the book. This is how Peter and I address all of these global studies, what we do everywhere on the planet. Desktop study, map and review the relevant coastlines for the states. Desktop study step 2, locate the land terminus point. This is the official starting point for all maritime boundaries. Peter mentioned that. Step 3, review each coastal state's territorial sea baseline model. That is normal and or straight baselines. Just a note, who like normal, they don't really like the straight baselines, and we know that from reverse engineering all these studies. Step 4, produce and review the legal limits. We're only looking at the 200-mile for this study. 5 is the critical one, maritime boundaries. We're going to import the bilateral treaty, both countries unilateral. We're going to offer the strict equidistance line, and then we're going to give a bunch of scenarios from past court judgments. And then we'll review the hydrocarbon. So, step 3. So, the relevant East African Indian Ocean territorial sea baseline models. Just to set the stage, Somalia claims strait and has legislation for straight baselines, but they're not publicly available. We did reverse engineer them in the desktop study. They can also legally use normal. Kenya published straight baselines in June 9th, 2005, and they also have never published but can make full use of normal baselines. Tanzania, Seychelles both use straight baselines as well, but they're in yellow because they're not really factored in that heavily, but we did need to look at it. So, law of the sea by the book, the regional neutral desktop study. Step 1, map and review relevant coastlines for all applicable coastal states. Now, this is the key setup when we do a desktop study. We need to sort of understand the coastal front. So this is our desktop study. It's a 1 to 7 million scale overview. Here's Somalia, here's Kenya, a bit of Tanzania, and the Seychelles way to the southeast. Showing you the relevant coastlines, there's about 239 miles right in proximity to the border that we need, about 472 overall, and about 234 that covers all of Kenya. And there was only about 70, but again, we're barely using it for Tanzania. So the primary focus is the coastal frontages here for the southern portion of Somalia. Even though Somalia is over 1,000 nautical miles long, we're only needing to look at the coastal frontier. Also, Kenya is along here. Desktop study step 2, coastlines. Use and review the best available nautical charts. Now the UN guidelines are very specific in this. They tell everyone this is your starting point. So here is a current UKHO Admiralty chart. 350,000 scale is quite small scale. It was published in 1997. But you do have to understand what is the data collection and the nearshore, foreshore, offshore surveys. That's the key element here. So it does cover our coastlines, and we can look at this for coastline evaluation. It does give us information for the coastline, and it does allow us to go and look at initial analysis. So let's go and look at these coastlines a little bit closer. So looking at just the border region where we need to do all our analysis for the desktop study for the baseline, here is a detailed zoom in, 100,000 scale of that UK chart. You'll see that there's low water lines. You'll also see the land boundary is on here. We also brought in a second source, Navionics 7 Seas, which is also 100,000 scale, shows about the same detail. But you can see the islands and the coastline are very, very smooth and generic. And that's because these were mapped 50, 70 years ago. So they're just hand-drawn renditions, sadly, on the chart. So you do have to consider that while we're doing the desktop study. Relevant coastlines. Now, this is basically how we're depicting this. And you're seeing from the border, from the land terminus point, we're using about 234 miles for here, and about the same, just a little bit more, 239. After that, none of these features and offshore features factor in for doing the mathematics behind how you generate a boundary. So the next step here, maritime boundary dispute, just so that we identify the overall region. This is what we, in our neutral desktop study, will refer to as the relevant offshore area. So we're going to look at anything and everything within this shaded red polygon. So this is where we're going to do all of our analysis. And I can tell you there's been over 1 gigabyte worth of data that we assembled and we analyzed. Step 2 in the desktop study, locate the land terminus point. Now this is going to be a huge effort that we need to do. Some countries have spent up to a year just spending time to locate this land terminus point. Okay, analyzing our data set. Again, here's our desktop study. We already know that obviously there's a frontier for Kenya, Tanzania, but we're not going to look at that much, and I'll explain to you why as we analyze the boundary. So here's the critical focus area. The land terminus point needs to be located for Somalia, Kenya, in order to generate a maritime boundary. So how do we do this? We're going to go through a bunch of steps. This is using some topography data. This is a wonderful land-based 3D elevation model. Again, homing in here on the coastal area. So we're coming from land, but the land terminus point is where land terminates into the sea. So this is somewhere in here is the probable area that we need to locate this land terminus point. But we need to have a whole bunch of different data sources to try and identify this information and to see how this comes together. We normally go back through history. Here's a wonderful old US defense map that actually shows the land boundary. And again, even in here, it shows the approximate general location with some features coastal. But this is old. This is from 1976. Again, we've already seen this nautical chart. Again, we know there's some small islands near shore here. We know there's a land boundary. But more importantly, if you bring in some old data, this is a Kenyan Gazette, officially from 1973. They talk about the pillar number 29 being the terminal pillar of Kenya, Somalia. They even give a very crude latitude and longitude. Keep in mind that's old mapping. So let's bring this to present day. Here's a wonderful 1 meter Apple map image. These, the Uatu Damascus, I'm going to pronounce that name always wrong, but these 5 islands offshore are critical. You'll see that there's a boundary down here that is the 4 meters that is described in this CIA document that we made use of. It talks all about describing Dick's Head, and it also talks about where the coast shall be terminated down here. So this is Kenya, Somalia, location boundary pillar 29, as we have researched it. And again, you can see on this image, this is Somalia and this is Kenya. So this is the land border. Okay, moving on to the next step. We need to desktop study 3, review each coastal state's territorial sea baseline model. Now, straight baselines and normal, we're going to begin looking at straight, but I do have to stress that the courts really do prefer normal baselines. This red line depicted here, this shows Kenya's published on July 22nd, 2005, their straight baseline. Here on June 30th, 2014, and Peter and I had to reverse engineer it because they didn't actually publish the individual points. They gave us the 200-mile, so we had to reverse engineer it, but that represents Somalia's straight baseline. Now, using present-day imagery, we always do, we evaluate everybody's base points. We've done this for studies for, I was involved with over 100 countries doing this worldwide for various government agencies. And what this is no fault of any coastal state, but these show the Kenya has 10 published straight base points from 05. And you have to understand, law of the sea is all about precision mapping. That's where their base point is, and you can see there's land actually to the east of it. Here it's going over land. Here an island was missed, and here an island could be utilized. So we actually saw mismatches of up to 500 meters. So that is just some disparity that could be used for additional work. So what do? Well, this is something new that we have developed. It is using satellite imagery for preliminary shallow water mapping application. And in this case, neither Somalia nor Kenya have published normal baselines. So again, from all these diagrams and from this image here at 25,000 scale, you'll see the land terminus, the boundary pillar is down in here. And using normal baselines and using these figures, we have interpreted using this present day satellite image from 10 months ago, we have mapped the normal baseline. So that's the low water line. So there actually is the first time we're looking at the land terminus point. And that's the same procedure that was used in the Ghana Cote d'Ivoire case, whereby the tribunal moved the point. The other thing to take note of is these thousands of offshore features, low tide elevations for islands, islets, drying reefs, and rocks. All of this is 100% eligible to be utilized by both Somalia and Kenya when producing maritime boundaries. And you'll see they're offshore. Now, keep in mind, this is preliminary. This is not 100% survey quality. You still need to blanket map these frontiers with proper surveys. So that is a warning flag, but this is how we do this in a desktop study. Okay, utilizing those baselines that we've analyzed. Step 4, produce and review the legal limits. We're only going to do the 200-mile for the desktop study area. So again, looking at our desktop study area, from here, from all those baselines, Somalia will produce 200 miles for their EEZ. Kenya, for all the baselines, 200 miles. Tanzania, 200, and from the Seychelles. So this red line is defining our 200-mile EEZ. So there we have it. We now have our 200-mile. And the focus is going to be what is EEZ waters and eventually what is the ECS waters. Moving on, step 5. This is the heavy-handed part, maritime boundaries. We will be importing existing bilateral treaty agreements. Type 1, these are published. Type 2, unilateral. These are the suggested boundaries by both Kenya and Somalia. So these are hypothetical, but they're unilateral. They're type 2. Number 3, strict equidistance, where we will give neutral computed lines. In step 4, we're going to give a couple of considerations from various past court cases. So we're going to in all cover 5 lines, but there could actually be about 15 lines that we do, but time permitting, we're going to pick the main ones that we're going to look at. Again, here is our desktop study. Here we're first looking at type 1, treaty. We have in here the historical treaty for the territorial sea between Kenya, Tanzania, July 9th, 1976, that covers the territorial sea. We have April 2nd, 2009, they negotiated the EEZ maritime boundary and went on and did the ECS boundary. The focal point for today's study primarily, of course, is the unresolved boundary here. Here is again that CIA-US document from 1973, which basically is an interpretation of the treaty July 15, 1924, with modified exchange of notes that are critical that we found of 22nd November 1933. But that represented the UK, Kenya now versus Italy, Somalia now. The takeaway points are the southern terminal point should be 15 meters inland from the watermark, known as Dar es Salaam. It also talks about the southernmost of the group of 5 islets. So Damasco is going to have to be looked at. And so here's the critical thing. In a southeasterly direction, to the limit of the territorial waters in a straight line at right angles, general trend of the coastline at Dar es Salaam, leaving the islets in Italian territory. Now, this was really interesting for Peter and I when we stumbled on this. And again, we try and approach this just purely from a neutral's point of view, having done thousands of these studies. So let's try and reverse engineer that. Here are the 5 islands. You can see them offshore. Here again is the land area, but critically that document from 1933 states, taking the southern of the 5, a perpendicular line back to the coastline, where the land boundary will meet at pillar 29, and then it could move to the low water line. But it actually goes one step farther. For both of us, this was extremely interesting. It talks about taking the perpendicular line right at Dar es Salaam, which we did. It's about 35 degrees. Running a perpendicular line straight out. So this straight perpendicular line, it's about 125 degrees to the limit of the territorial waters. Now, territorial waters for Somalia and Kenya both would be 12 nautical miles. Of course, we do not know if it is uncertain how the ICJ will interpret these 1924 treaty. Pete, I believe you have a few words at this moment.
Yes, so from the international lawyer, it will be interesting to see how the ICJ will interpret the Italy-Great Britain Treaty of 1924 and the exchange of notes of 1933 that Somalia and Kenya inherited from the colonial powers. Now, Somalia and Kenya may be in agreement that the treaty did not delimit any maritime boundary, but the ICJ can be expected to do its own analysis and interpret the treaty according to the established rules of treaty interpretation codified in the 1969 Vienna Convention on the Law of Treaties, which is binding customary international law for Somalia and Kenya. And the starting point for interpretation is the ordinary meaning to be given to the terms of the treaty in their context and in the light of the treaty's object and purpose. A special meaning is given to a term if it is established that the parties so intended. It is not clear that such evidence exists here. The words, quote, to the limit of territorial waters, end quote, must be given effect, it seems to us. Rob?
Thank you, Peter. Okay, so based on that, we're calling that a historical treaty question mark. And here is going to be some boundary analysis now. So again, set the stage, a 1.15, 1 to 1.5 million scale. Here's the relevant 200 mile. This little first segment is what I just displayed. And again, we're just calling that the historical treaty line, possible. Again, this has got a question mark onto it. The next line, this is the unilateral line claimed by Kenya, June 2005, with publication of documentation, and it follows a parallel of latitude. The counter line, so that's a unilateral line here, is the Somalia line, July 2014, which runs as a line down in here. But what this is critically giving us is the overlapping claims area, also referred to as the OCA. It's about 50,728 square kilometers by our calculation, based on all the analysis that we have done to date. Moving on now, maritime boundaries, type 3 and type 4. Okay, type 3 and type 4. These are computed, so this is in the desktop study. And again, we're going to fix all our boundary lines onto the end of that potential historical treaty. I've already mentioned both Kenya-Somalia straight baselines. When we draw it out, you can do strict equidistance line. It gives a very lopsided 98.5% of the OCA to Somalia and 1.5 to Kenya with that line. But again, some of the straight baselines are somewhat questionable for Kenya. The opposite would use the normal baselines. And again, I warn you, these are from our 40 SSM mapping, but it ends up giving an 86.2 to 13.8, where you see the line is migrating up towards the middle. Here's a complete different one, but we did want to consider it because marine protected areas, which Kenya does have historically here in the Kiungu Marine Reserve, and or considering fisheries, there is a past court case where Jan Mayen, Denmark, Norway in '93 used that to give a split of the waters 50-50. So we draw that as a possible line. A complete different one that I still thought was useful was a combination line here used by the courts in January 2014, Peru, Chile, whereby they give consideration of one country's parallel line and the other's strict equidistance. And then we consider the final one, which is really gaining traction in the last couple of years, which is the onslaught of the extended continental shelf. Here's Kenya's claim, about 93,300 square kilometers, lodged 6 of May 2009. Here, directly on top of it, is part of it in our desktop study, showing Somalia's July 2014 claim. It's only about 127,000 square kilometers, the area in yellow, but their entire is almost 900,000 square kilometers, which is 10 times the full claim of Kenya. So keep that in mind when you're thinking about equity and fairness. But the OCA or overlap is about 76,353. So we did some splitting of some math. There's 4 past recent court cases that all made considerations of shifting the line in the name of equity because of the extended continental shelf, and that would give it a 60-40 in the ECS and a 50-50 in the EEZ. But to wrap things up, it does make both of us ask the question, are these overlapping areas, the EEZ and the ECS, a candidate for Joint Development Zone, Joint Development Area, JDA? This was a solution for similar disputes now in some 22 areas around the world. So I do throw it out there. Now, why is this all important? Last step, hydrocarbon. I've already mentioned that area is potentially rich. We're going to review regional existing offshore seabed activity, only the hydrocarbon industry. These are blocks that are open, defined by the countries, blocks that are issued to oil companies, current bid rounds that are active, and future bid rounds that are pending. All of this needs to be considered when we're looking at this offshore frontier area. And keeping in mind, all these blocks I'm going to mention to you are coming from a third-party product called Drilling Info. Again, just a disclaimer, these are as is, these are shown, but they are from April 2020. The orange area is the OCA ECS, and the yellow area EEZ, and this is the ECS. These red blocks, Kenya has issued them, but they're all open. So they're out there, but they're not held by IOCs. These 3 green ones and these 3 green ones in the OCA are issued to international oil corporations who hold the right to explore. There is also a future bid round that's on the books about 1 year from now, July 2021, and you'll see there's several blocks that encroach into the overlapping claims area. Somalia has all these open blocks at the border region, and interestingly enough, they even go beyond the OCA. There's 2 green blocks issued as per Drilling Info, but it's outside of the overlapping claims area. But interestingly enough, there is, as per Drilling Info, there is current bid round with 2 blocks that lie in near proximity to the OCA. And what this finally all summarizes is present day offshore hydrocarbon blocks impacted by the overlapping claims area dispute. Kenya has 8 and Somalia has 18 in this figure. Pete.
Thank you, Rob. So switching it to the private sector and the legal perspective quickly, the question can be raised, does the private sector, does the petroleum industry have a role to play in boundary disputes between coastal states? After all, concessionaires or licensees are directly affected by a maritime boundary dispute, as Rob just showed. And as a rule, this is the purview of sovereign states. Oil companies cannot be formal parties to boundary cases. So you will not see an oil company appearing on the side of other party before the International Court of Justice in The Hague. But foreign companies can and should work with the disputing states. And the goal here is to be a help, not a hindrance. And help means providing geological or other data to both states if requested, or identifying experts, such as Rob Vanderpoel, provided this is done in a neutral way. Foreign concessionaires should take care not to take sides with one state over another and refrain from aggressive lobbying. And some caution and restraint are called for. Rob?
Okay, thanks again, Peter. That actually concludes the initial portion of today's webinar. That is all from Peter and myself. We'd like to thank you for allowing to present this. And at this moment, I will hand the floor back to Madam Chairperson, and she can take over.
All right. Well, thank you much, Robert and Peter, for that very, very riveting presentation. I would like then to get a few comments from Abdul Abdurahman and Mumma. I'll start off with Abdul. Maybe in 5 minutes, can you give us of Somalia's approach and stance in the dispute?
Well, you know, as a background, I'd like to point out that Somalia is emerging from 30 years, a civil war that had gone on for 30 years since 1990. And with regard to the current dispute, the general feeling within the Somali government, which I believe informed its own decision-making during the dispute in front of the International Court of Justice and within the Somali population, is that while Somalia was involved in all of these issues and conflict during the civil war, that Somali territory. Now, I want to make very clear that when I say Somali territory, that this territory is still subject to contested claims from both sides. But from the Somali point of view, that they believe that they have sovereignty and exclusive jurisdiction in this area, and that Kenya had issued concessions in this area to foreign oil companies that have started operations. So within that background, there were some negotiations that took place to settle this contested claims between Somalia and Kenya. These discussions went on in 2014, I believe, from February to August. And during those discussions, the two parties not only couldn't agree on a settlement, but they couldn't even agree on what type of method should be used to delimit the joint maritime boundary. And looking at the timeline that Somalia had set out in its memorial that was submitted to the International Court of Justice, it appears to me that Somalia from the outset was prepared for two outcomes. One outcome was to settle the dispute through bilateral negotiations and agreement with their Kenyan counterparts. But at the same time, it appears from, to me, from the timeline in the memorial, that Somalia was also prepared for the eventuality of a failure in these talks. And I do base that on the fact that within the timeline of the negotiations between Somalia and Kenya, the Somali government submitted the case to the ICJ within days of the final contact made by the Somali Minister of Foreign Affairs to his Kenyan counterpart on, I believe, August the 26th. And that contact referenced meetings that had been scheduled prior for the 25th and the 26th in Mogadishu to continue negotiations. And Kenya did not turn up for those meetings. And now this is the position of the Somali government. And at that point, the Somali government reached that any further negotiations on this issue were fruitless. And Somalia's position has been that in the spirit of the United Nations Convention on the Law of the Sea, that Somalia has fulfilled its obligation to enter into good faith bilateral negotiations to settle the boundary dispute. And that since that have failed, that now they are going, now they have submitted the claim to the International Court of Justice to settle the matter. And Somalia has requested that the method that should be used should be the equidistance method.
Okay, thank you very much, Abdul. And Albert Mumma, let's hear from you regarding his approach and stance in the dispute.
Okay, thank you very much, Wairimu. I think what is quite clear is that, you know, Kenya was obviously taken by surprise when Somalia filed these proceedings at the ICJ. It would appear, of course, that Somalia, on the other hand, you know, had been preparing for these kinds of proceedings for quite a while. You know, Kenya had assumed that, you know, first of all, there was a framework for reaching a negotiated settlement. And secondly, that, you know, negotiations were in fact going to take place, you know, after the delineation of the outer continental shelf by, you know, that, you know, so they were not at all prepared and were quite surprised. Now, it is also the case that, you know, I think given the history of Somalia that Abdul has indicated, where for a very long period of time, Somalia has had internal conflict and internal instability with considerable impact on Kenya's own stability in terms of, you know, security in issues, in terms of the fact that Kenya has hosted the, you know, in the past, the Somali interim government, in terms of the fact that Kenya hosts a large number of, you know, Somali nationals who are displaced. The reaction of the Kenya government, I think, and of the people of Kenya, you know, was one of not just surprise, but, you know, a thought that somehow, you know, this was a slap in the face. So that, I think, characterizes, you know, the stance that, you know, and the reaction that Kenyans had to these proceedings. Nevertheless, I think what Kenya did in the first instance was to object to the jurisdiction of the ICJ on the basis of a memorandum of understanding that had earlier been agreed between Somalia and Kenya, which had made reference to the fact that there would be a negotiated approach to delimiting the boundaries, the maritime boundaries between the two countries. But I think it is common knowledge now that that objection to jurisdiction failed, and the International Court of Justice came to the conclusion that that particular memorandum of understanding did not, in fact, provide for an alternative approach to reaching an agreement on the negotiated boundaries, on the disputed boundaries. In the end, I think what Kenya argues is that, you know, the proper position which should be adopted is to delimit these particular boundaries using the parallel line. And the reasons that Kenya advances are essentially that, on the one hand, you know, historically for a long period of time, dating back at least to 1979, Kenya has exercised jurisdiction over this particular contested area, and there has not been any protest, any challenge from Somalia to Kenya's exercise of jurisdiction over that area. The first challenge comes, you know, just at about the time before these proceedings are filed. So I think Kenya argues that, in fact, if you look at that, then you can see that, you know, there is a legitimate claim by Kenya. But secondly, they say there is regional practice, which has been adopted between Kenya and Tanzania, between Kenya and Mozambique, between Tanzania and Mozambique for that kind of parallel line. And these are some issues, obviously, which I'm sure will be put before the court when Kenya finally files its response. But basically, that I think has been Kenya's stance with regard to this particular issue. Thank you.
Thank you very much, Professor Mumma, for those comments. I think I'll dive to you, Abdul Abdurahman. We've heard from Professor Mumma. We've also had the presentation by Robert regarding the various options that can arise in this matter. What are the lessons from Somalia's perspective? Of course, not speaking on behalf of Somalia, speaking in terms of what Somalia is doing presently and the new developments seen on Somalia's side. Take us a little bit through that.
As I previously indicated, Somalia during the 30-year civil war was not active in the offshore. However, since 2013, the representatives of the Somali government in the international field have been extremely active in engaging with the international oil companies with regard to prospective blocks offshore Somalia. Currently, I believe there are a little over 200 blocks that have been identified as available. That have been delineated by the Somali government. However, and also last year, I believe it was February 2019, Somalia held a roadshow in London to showcase the developing petroleum law at the time, and also the blocks that might be on offer. I'd like to make it very clear that during these presentations, Somalia did not indicate in any way that it was setting up either for auction or for bidding or even for availability, any blocks within the contested area. However, just north of that contested area, there are several blocks that have been identified as extremely prospective and containing possibly large quantities of hydrocarbons. With regard to that, Somalia has been very active in putting together a new petroleum law to take over from the last petroleum law that was passed in 2008. The new petroleum law that was signed into service by the Somali president in, I believe, February 2020, a few months ago, essentially is very similar to the 2008 petroleum law. And that petroleum law creates a Somali National Oil Company, which would be the focus of authority to sign international oil agreements. Within Somalia, there is, Somalia has adopted a federal system. And I'd like to point out that within the federal system, there are several member states, and to a large extent, the member states are, I would say, as powerful as the central government with regard to actual authority on the ground. And there have been very spirited negotiations back and forth between the member states and the Somali government. They have come up with a revenue sharing plan that was attached as an exhibit to the, what I would say, embedded into the new Somali petroleum law to satisfy the member states. But the power to make decisions, the power to make, to negotiate and sign international agreements now seems to have been given to the federal government. Clearly, this simplifies things for the prospective international oil companies, because then they have one entity to deal with regard to Somalia. Somalia is still apparently working on its tax laws to so that they can ensure maximum revenues from any oil deals. Nothing to my knowledge, there has not been a fiscal regime that addresses hydrocarbons or possible revenues, or even for example, if one of the oil companies wishes to farm out any of its interests in a block, I don't believe there has been any tax code to ensure that that process is taxed, and that whenever a taxable event takes place in any of these, negotiations, that the Somali government is able to tax the event and ensure that they get revenues. But I would like to say that Somalia has been remarkably quick, remarkably aggressive in the international arena. Just this week, Somalia announced a new bid round. They have offered 7 blocks. None of these blocks are within the contested area. I believe there is one block that's adjacent to the Jubaland member state, block 204, that's available, that Somalia has made available for bidding. So they are moving on. I'd like to touch upon one quick thing also, though. Within the contested area, as previously stated, Kenya has issued some concessions to some companies, and in Somalia's memorial that they submitted to the International Court, part of it is that it is looking for a ruling that would allow it to declare that any action that Kenya has taken has been, a violation of Somalia's sovereignty and jurisdiction. I believe that particular, request to the International Court is basically a building block for how Somalia will deal with the concession holders in the area. And I don't believe that Somalia will respect or continue to continue the concession rights of any of those blocks should the International Court of Justice rule in its favor.
All right. Thank you very, very much, Abdul, for your thoughts on Somalia's stance and certainly the lessons from Somalia's perspective. I will double back to you, Professor Albert Mumma. Are there any additional lessons that you would want to share with us from the Kenyan perspective that arise from this dispute?
Yes, I think, Kenya basically indicated at the start of this, dispute that it remains committed to a negotiated settlement. And I think that, when you look at the nature of third-party dispute resolution, then you can see that there are, in fact, quite a number of pitfalls associated with third-party binding dispute resolution. It is true, I think, that from the point of view of, the oil and gas sector and those who are interested in exploration activities, that they would like clarity and certainty in regard to the respective, the country's respective jurisdictions over this contested area. And therefore, they would probably view a decision from the International Court of Justice as helping in the process of clarifying who has jurisdiction and giving them some security over the investments that they are making there. And that is, an understandable, perspective from the point of view of investors. But then third-party dispute resolution, such as the decision of the ICJ, has certain serious shortcomings. One is, of course, the fact that, whereas in the short term it might give countries, whoever it's a winner takes it all, outcome. That one country will win and another one will lose. The winner will have a psychological boost, but this and the loser obviously will be quite unhappy about the outcome. But even for the winner, these kinds of psychological boost is really short term, because in the end, what one is looking for is to have a framework in the area that would facilitate and incentivize, investments in the oil and gas sector, And that framework will not come when you have regional tension, when you have bilateral tension. And these tensions are likely to be exacerbated by a third-party dispute resolution approach, which leads to, a winner-takes-it-all outcome. And so I think myself that what one should begin to think about, even as we approach the actual hearing at the ICJ, is a framework for cooperation beyond the decision of the ICJ. And I would argue that because if you look at this particular region, if you look at the countries concerned, I mean, there is a great deal of insecurity, instability. The area is prone to a lot of, terrorist attacks. The sea itself is subject to incidents of piracy. That's not an environment that will encourage any investment that can be sustained. And so even though one gets a decision that says the jurisdiction falls within country A or country B, what is assumed to be the consequent benefits in terms of investment in the oil and gas sector arising out of that kind of decision, in my view, will not be forthcoming unless there is a framework for cooperation which allows the area to move in the direction of stability. And that can only come if people begin to look beyond the ICJ decision so that they begin to establish a framework for cooperation of that kind. And that for me is the message that I think we should take away from this particular session. Thank you.
All right. Well, thank you very much to the panel and to both Abdul and Albert, Professor Albert Mumma and Mr. Abdul Abdurahman, for their comments on what we can see and the lessons that we can learn from each country's perspective. Now, I'd like us to get into the Q&A session, and I'm sure all of you have had, we've had several questions, more than 12 questions in the group chat. Thank you very much. Some have been answered by the panelists. I can see a lot of activity with Professor Bekker on answering the question. Now, I'd like us to, if you ask a question on the chat, it's most likely been answered. There is a question that was asked, just give me 1 minute, on what would be the best option on resolving the dispute. Now, not being speculative, but I think we can have maybe some additional remarks from you, Abdul, on where you perhaps see Somalia getting in terms of a win-win situation before we get into the Q&A.
Somalia has taken the position that they have fulfilled their obligation to negotiate in good faith with Kenya, and that following those negotiations, which in Somalia's memorial was termed as fruitless, Somalia has decided that its only option is to take this case to the ICJ. Somalia is extremely confident, it looks like, that the ICJ will rule in its in its favor. Whether that would happen or not, clearly is still speculative, because, as was pointed out by Professor Bekker, that the ICJ has its own ways of looking at legacy colonial agreements and boundaries delineated in the past on the land, which may extend to the maritime sector as well. So we don't really know exactly what the court is going to do. But Somalia is very confident, that the equidistance line, which has been much favored in the past, would be the method that would be used in delimiting the boundary, the maritime boundary. So at this point, I don't believe that Somalia is open to any more negotiations. Now, with regard to whether the case going to the ICJ would cause some problems within the Horn of Africa area is open to question. What we do know is that there have been some low-level issues between Somalia and Kenya, but nothing very serious that would impede the case going forward at this time.
All right, thank you. I will also ask for additional comments from Professor Albert Mumma, especially with regard to the Kenya's lessons in some of the negotiations and disputes that it has had with other countries. You mentioned Kenya, Tanzania. Whilst Professor Mumma is answering that question, I have, by public demand, been requested to allow for participant questions audibly, to have about 2 or 3 participants ask questions. If you have a very pressing problem, which you commit to ask in 1 minute flat, please use the raise your hand icon on your chat icon so that we can see who has raised their hand and they can be unmuted to ask the question. Professor Mumma, over to you.
Yeah, thank you, Wairimu. I think basically my own view, and I think as I indicated at the start, I do not believe Kenya had seriously put an effort into negotiating this issue at the start. I believe Kenya was rather surprised by the fact that it was presented to the ICJ. In terms of whether or not in the future a negotiated settlement might, some sort of a negotiation to find a framework for cooperation might still be the way to go, I think one of the points I would like to highlight is that in the claim presented by Somalia before the ICJ, they are also looking for reparations. They're basically saying that, their sovereignty has been violated, and they would like to be compensated, and, just assume for a minute that indeed that was to be granted, then there'll be a long process of pressing for that compensation and the associated friction that would arise in that process. But also, if one looks at the claim by Somalia, particularly if you stretch that equidistant line further down, it actually ends up overlapping with Tanzania, which then means that Kenya would be facing the prospect of being sea-locked between Somalia and Tanzania. That is not a prospect that any country can view without considerable alarm. Therefore, I personally think that notwithstanding the fact that the ICJ hearing is approaching, looking ahead, taking the long-term view, I think sustainability of cooperation in the area requires finding a collaborative framework. Now, in a collaborative framework, as they say with negotiations, one must be willing to compromise. If you are not willing to compromise, there is no point negotiating. And therefore, the timing of the negotiations is important because, at the time when I think, as Abdul says, Somalia is quite confident that they will come away with a win, then they are not likely to be open to any other approaches to discuss. And so, the timing, probably has to take that factor into account. Negotiations never end, and I personally do not think that the ICJ decision should be seen as the end of the game. Thank you.
All right. Thank you very much, Professor Mumma. I will now call on Professor Pieter Bekker. There have been quite interesting discussions on the group chat, and thank you for answering most of the questions. There is one question that I find quite interesting for you to address from Njoki M, and it says, while IOC's international oil companies would ideally be expected to not be parties to the ongoing dispute between Somalia and Kenya, this assumption has over time been established to be flawed. They are not bystanders. Can you please comment on that?
Yes, thank you, Wairimu. We all know that the oil and gas industry and concessionaires, of disputing parties are all directly affected by a maritime boundary dispute. They want certainty. Their investments are very large and risky. So when there is uncertainty as to who has title, has the sovereign rights to oil blocks offshore, obviously that's a situation that is not ideal, and it could flare up. We have seen that, especially when the international relations between two countries are under stress, are less than ideal. And we have seen in other cases that the oil and gas industry can be directly affected by that, even with states bringing in their naval vessels to shoot at survey or exploratory drilling vessels. So I think the oil and gas industry is not a bystander in the sense that they will just wait and see what happens in this case. They can be expected to engage actively with the state that issued the concessions. But as I mentioned, they have no formal role. You will not see them appear before the ICJ on the side of Somalia or Kenya. But they have to be very careful, as I mentioned.
All right. Thank you very much, Professor Bekker. I'll now turn to you, Robert. Now, Professor Mumma, in his commentary, brought in an interesting aspect of the fact that if the court was to decide using the distant line principle, Kenya might find the boundary would extend from Somalia to Tanzania, and Kenya might find itself sea-locked. Again, not to speculate, but have you in the past, and I know you've done a lot of mapping and surveys, encountered situations where countries have been sea-locked or potentially sea-locked because of the extension of maritime boundaries? Thank you.
Thank you, Wairimu. When Pieter and I looked at this circumstance, this does have some similarities to a huge similar dispute that was Bangladesh versus Myanmar, Burma, and Bangladesh versus India, because in their circumstance, the same thing was potentially happening with the first that went to the court. The boundary was actually seen to be cutting off the access, as Albert mentioned. So there is some considerations that could be made for that. We do know that there is a treaty between Kenya and Tanzania, so this line would actually bring Somalia potentially into conflict with Tanzania. So all these things should be considered. So, but when we did the analysis, that was one of our observations. So the Kenya may look to what was decided on those various court cases for Bangladesh. That may also give some insight on how to handle this case. Thank you.
All right, and I think I'll double back to you, Professor Bekker, as a follow-up to what Robert has discussed with regard to Bangladesh v. India and Bangladesh v. Myanmar, and the potential that Somalia might find itself in conflict with Tanzania with regard to Tanzania's agreement with Kenya. Have you faced, again, not being speculative, but have you faced such a situation where you have a third-party country then being embroiled in a dispute because of a present dispute, whether in an international court or in a tribunal?
So let me first point out, thank you, Wairimu, that this case is a bilateral case and it has no consequence for any of the neighbors. It's going to be a ruling, if we will have a ruling from the ICJ, that is final and binding only for Somalia and Kenya. Now, as to the regional setting, and there's a reason why we described it, there have been rulings that said, well, you need to take into account regional boundary arrangements. For instance, in the case between Guinea and Guinea-Bissau, another African case, the court said a delimitation designed to obtain an equitable result cannot ignore the other delimitations already made or still to be made in the region. And then the tribunal in that case looked at the whole of West Africa. So it's uncertain as to what role other agreements by Kenya will have made, but it's very clear that what happened in the southern border is a contract, a deal made between Kenya and Tanzania, which is not binding on Somalia. And then finally, I would say no ruling by the ICJ, and as I mentioned, there have been a dozen or so, is going to be binding on the court itself. So it can ignore what it has ruled in other cases and also what other arbitral tribunals have ruled. So there's an element of uncertainty there, but by and large, there is a jurisprudence so that we can make informed predictions as to what might be relevant to solve this particular bilateral dispute. Thank you.
All right, thank you very much, Professor Bekker. I'll come back to you, Professor Albert Mumma, and when Albert speaks, I'd also like us to hear views from Abdul. There was a question by Sharmak Farah. I hope I'm pronouncing it correctly. The 1924 treaty is irrelevant as both Kenya and Somalia were occupied by the foreign powers who had no consent of the local communities. Professor Mumma, can you tell us a little bit what you think is the public international law status of the 1924 treaty? So again, not speculating as between Kenya and Somalia, but pure public international law. What is the status of your view?
Oh, thank you, Wairimu. No, it is not relevant at all. The position in international law is that treaties dealing with territorial boundaries are treaties which, notwithstanding that they were entered into by colonial powers, would remain binding unless denounced by the country that then became independent. Now, in this particular situation, there is no denunciation, and therefore relevance does not come in. The fact alone that these were colonial powers is not at all a basis for arriving at the conclusion that it is irrelevant. The point, though, that I think is important to highlight in looking at that treaty is that primarily it dealt with the land boundaries, it dealt also with the territorial sea, and the UN Convention on the Law of the Sea now provides the framework and the basis for delimiting this contested EEZ and continental shelf area. So whereas the treaty is relevant, it does not mean that the treaty necessarily determines the issue. And I think that is a point that came out earlier. But under international law, there is no automatic assumption that the treaty has no relevance. Thank you.
All right, thank you. And Abdul, what is your comment on that?
Well, I think that, as Professor Albert mentioned, neither Somalia or Kenya has attacked that 1924 treaty. So there is a sort of an implicit acceptance of the treaty and the terms that are in that treaty. But still, as Professor Bekker pointed out, the ICJ has its own ways of looking at things, looking at the documentary evidence that's available. And certainly the 1924 treaty will be looked at by the ICJ. What decision it will base on and what effect it would have, extending from the land terminus point to delimit the boundaries is really up to speculation at this time. I'd like to also point out that, following independence, most of the African countries, within the OAU made a declaration that they would accept those colonial boundaries. Somalia has made, at the time there was some boundaries primarily with Ethiopia that Somalia never really accepted as being the true boundaries of the Somali Republic. But that issue itself would be outside this current boundary dispute. So I don't think that the 1924 treaty will have much impact. And as I mentioned before, neither country has made any reservations about it. So I'm assuming that it will be clearly not affected.
All right, and moving, so thank you very much for that, Abdul and Professor Mumma. Moving away from that, we have an interesting question from Abukar, which I will pitch to you, Robert. He says, or she says, sorry about that, in many maritime disputes, special circumstances and relevant circumstances are mentioned. Can you please clarify the difference between them and which one Kenya is, and which one Kenya would claim or use in their favor? Now, I guess that's a bit speculative, but do you have any comments as to special circumstances versus relevant circumstances?
I have to be honest there. I think that's actually a better question for Pieter as we work together. Pete, do you actually have a better way of describing that? I know the question sounds like it's for different data sources and different relevant portions of the coastal front, but I think that's more a legal question. Pieter.
Yes, I can address that question as the law of the sea legal specialist. So special circumstances are mentioned in Article 15 of the UNCLOS, which deals with the limitation of the territorial sea. And it mentions the median line failing agreement of the parties. Relevant circumstances are essentially the same concept, but that has been developed in the jurisprudence regarding the limitation of the exclusive economic zone and continental shelf. As I mentioned in my opening remarks, relevant circumstances might come in to adjust or shift a provisional line. And there, as I mentioned, geography rules. Now, there have been cases, as Robert mentioned, where fisheries were a relevant circumstance. So dependency on fisheries could come in here. I don't know what the Kenyan fisheries dependency is. Somalia has invoked it. In its case, we know that before the ICJ, but that was a document from 2015, and that's the only document that we have. I worked on a case between Denmark and Norway at the International Court of Justice when I was a staff lawyer, and that case essentially was decided by Greenland's dependency on fisheries. So that might be a factor, but oil and gas blocks typically are ignored by international courts and tribunals. Thank you.
Thank you very much, Professor Bekker, for that. Now we have 5 minutes to go till the end of the presentations. I will say a big thank you to the panelists, to Robert Van Ziepel, to Professor Pieter Bekker, to Mr. Abdul Abdurahman, and to Professor Albert Mumma. You have given very succinct views on an issue that is of great policy, public international law, and political importance. We have participants from diverse countries who have engaged and who have asked questions. So thank you very much for that. And I will give a small clap since we are not in physical presence to clap. Asanteni sana, as we say in Swahili. And to you, the participants who we have had the great honor of having you on board, thank you very much for coming on. And a big thank you to the Extractives Hub, to Victoria Nalula at the Extractives Hub, and to Jocelyn Omondi at the Extractives Hub, who have made this possible. This presentation is going to be available. Special thanks to Robert Van Ziepel for all the slides that you have seen. And special thanks again to all of you, my panelists. So at this juncture, I would say thank you and goodbye. We have not had any hands raised, but again, participants, if you have any questions, please feel free to email the Extractives Hub, who are going to put you in touch with each of the individual panelists to answer any questions that you may have. So thank you very much. Excellent presentations, as I can see from the group chat. And this message is going to self-destruct in 3, 2, 1. Thank you. Bye-bye.